right, good evening, good morning, good afternoon, whatever time that you are watching this video. I am Richard Taylor and I'm coming back with some more information concerning the case of Mr. Roderick Ricky Davis. Now, a few weeks ago, I had Mr. Davis on a live call from prison. He is currently serving 2 life sentences for a double homicide that occurred in August of 2006. Mr. Davis was the subject of numerous attacks, allegedly, by the individuals who ended up deceased. And his claim has been always self-defense as it is now. And he is currently trying to get back in court because of some new information that has been provided. Now, since that last video, if you haven't watched it, you can go back and get the backstory of it. And I'll go over a few of the details here. But I have in my hand a 34-page motion for appropriate relief that was sent to me by Mr. Davis by way of his mother and father. And if you don't know what a motion for appropriate relief is, that is after the trial or after a guilty plea or sentence. An individual has an opportunity to file an appeal. And with that appeal, the individual get a chance to state why and how they feel that their case should be either reheard or the case overturned. Now, after that appeal, if that appeal is denied, then the individual has one more option, and that is the motion for appropriate relief. And this is sort of a rebuttal to the denial of an appeal in which new evidence can be submitted, and also errors or arguments in contrary to what the judge had stated that denial of the appeal was based on. So I'm going to give you a little bit of backstory, but I'm also going to read you 2 affidavits that come from people who pretty much allege that Roderick Ricky was acting in self-defense. One individual actually writes an affidavit that he actually took guns out of the deceased's car, which would prove that Mr. Davis acted in self-defense. Now, during the trial, the prosecutor alleged and coerced the jury that, there was no self-defense involved. The people riding in the car who were deceased never had a firearm. And even as Mr. Davis states in this memorandum, that even his lawyer did not pursue the angle that the occupants of the vehicle that were fired upon by Mr. Davis had weapons. So that is part of his motion for appropriate relief, which, if in my understanding, it has been granted, but he has just not had the evidentiary hearing, which means they bring him back to court. I think he was granted the evidentiary hearing in 2020, but because of COVID, if you listen to the last video, he was not able to get back in court. So he's still waiting. But just to give you a little backstory on this, it was in August of 2006. Davis was 23. He was staying on Slaughter Street. And he was fired upon. Now, evidently, he was hanging with some guys who had some beef with some more guys from another side of town. So on the morning of the 19th, Davis said he walked out of his house, was talking to a friend who explained about a fight that he had with some other individuals. While he was talking, those individuals came by and fired upon he and his friend that were talking. He said at that time he briefly returned fire. Then he later figured out who the people were who were firing upon him. Now, that later on that same day at approximately 3 o'clock, Ricky said once again he drove up to his yard. He was standing outside of his yard, and the car rolled past, and he saw one of the deceased gentlemen ride by, and he fired 5 rounds towards Ricky Davis. Now, later, the next day, he actually ran into some of the individuals, told them, look, I don't have any problem with y'all. I appreciate if y'all stop, shooting at me. And, he went on about his business. But then the next day, he was fired upon again at his home. Now, at this point, one of his friends, Mr. Jamie Oates, who's deceased, may God bless his soul as well, but he was hit, and he was taken to the hospital during that day on the 20th. So the next day, it was when the incident that is the subject of the court case happened. David said he went, hanging out with some friends, smoking and drinking, and then when he got home, he saw somebody riding past his house, and they actually pulled in the front of his front yard, and he said that he ran out of the backyard because, of course, he knew who they were. They were firing upon him for the past, 2 days, 4 times in 48 hours. And that's when he ran out. He ran out of the back of his house to the next street over. He saw the car coming around the corner. He alleged that one of the victims in the car had a gun and pointed it at him with the intention of firing, and then that is when he fired upon the car. Later on in this memorandum, it says that he fired about 15 times as opposed to the people in the car firing 3 times. And he, left the scene for a while, went to his parents' house, and then the next day, he turned himself in after he realized that, he had a warrant. Now, this is where his case sort of gets murky, because after the shooting, it was apparently, or it has been alleged, and actually 2 eyewitnesses stated that they saw a young man on a bicycle ride by and take 2 guns out of the car. And 2 of these witnesses, and their names are listed here, I'll say them because it's public record. Miss Pamela Carnegie says she lived just a few feet away where the gunshots were. And she said that she witnessed a black male on a bicycle carrying a gun while riding through the neighborhood. Now, also, Mr. William Battle also relayed to investigators that he saw someone on a bicycle remove a weapon from the vehicle. He also testified at trial that, he yelled out to the individual that, that was a crime scene and you should not be tampering with it. So both of those individuals gave evidence that there was possibly a gun at the scene. Now, on September the 21st, 1 month after the shooting, an individual named James Ray told investigators that he was on the bike at the crime scene, and told investigators that he stuck his head inside the car, but he did not remove a weapon. And also, James Ray was allegedly serving time in 2009 at the time of the trial. And he spoke to a private investigator who once again questioned him about that now, and he still stated that he did not take any guns out of the car. Now, on April the 7th, 2008, Mr. Davis was charged with about 15 counts. 19 charges. Two of them first-degree murder, and a bunch of other charges as well. Now, also in this motion for appropriate relief, Mr. Davis attended a test that he didn't receive adequate counsel. Now, the reason for this, because at this time, his lawyer was one Jeff Hoss Esquire. Now, this was in 2008, and if anybody remembers around that time, it was that time when Mr. Jeff Huss got into a physical altercation with his brother, fellow lawyer, attorney Mr. Bruce Huss. And during that altercation, Mr. Bruce Huss unfortunately died due to some sort of complications from the altercation. So, despite that, Huss continued to represent him. Now, during this time, Huss was probably, going through a lot of grief. This memorandum says he was in and out of the hospital for an undetermined period, while still trying to represent Mr. Davis. Now, Mr. Davis also alleged that before that incident happened, Mr. Huss had came to him with a plea agreement for 26 to 32 months for manslaughter. Now, after that, that situation with him and his brother subsided and he got back to business, for lack of a better word, that plea agreement was taken off the table, and Mr. Davis was offered 45 years, which he did refuse. Now, moving on to the trial, it says Mrs. Pam Carnegie, the one that says she saw a man on a bicycle, she refuted or retracted her testimony. Mr. Davis alleges that, his lawyer didn't even seek to impeach her on that testimony. And also, Mr. Battle said that he saw someone near the vehicle remove a weapon and take off on a bicycle. Now, the most, common sense aspect of this case, which would prove self-defense, is SBI agent Neil Morton, a firearm analyst, testified that a 40 caliber shell casing was located in front of 801 Olivia Lane, which matched a 40 caliber shell casing found at the defendant's home from a previous shooting. Now, also, it was alleged through further investigation that there were 3 rounds fired from the vehicle that day of the deceased men. But no one mentioned that at trial. And so that is one thing that Mr. Davis contends, is that, his lawyer failed to offer, those reasonings as of, why he fired upon the car. So there was definitely some inadequate representation, because if there's state's evidence, there's ballistic evidence, there's physical evidence that, the people in the vehicle fired some shots. There were some shots fired from the car. Then that would definitely substantiate Mr. Davis's claim of self-defense. Nevertheless, the jury found him guilty in 2 cases of first-degree murder, and they sentenced him to 2 consecutive life sentences without parole. They also, upheld a couple of those other minor convictions. Now, in 2009, he filed an appeal based on new evidence. Now, this new evidence is an affidavit, and I have that affidavit right here. That affidavit is written by Mr. James D'Angelo Ray. You see the name right here. Now, this affidavit supports his Mr. Davis' claim of self-defense. And the affidavit confirms that Mr. Ray did in fact remove a weapon from the crime scene. Now I'm gonna read you this because it's very relevant to this man's case. Once again, if someone has been firing upon me for 4 days and I return fire and defend myself after they came to my home for 4 straight times, I don't think that I would be liable for the results of that action, and also I don't think I should be languishing in jail just for defending myself. So I hope this gives somebody, people some clarity, and maybe someone can come to Mr. Davis's aid in this manner. But I'm going to read it. It says, I, James D'Angelo Ray, being duly sworn, deposes and states as following under penalty of perjury. I have known Roderick Miles Davis Jr. since 1998. I know him by his nickname Ricky. I am giving this affidavit to Patrick Miguel Maguero, who introduced himself to me as Ricky's attorney. I make this statement and affidavit of my own free will. Nobody has forced me to make this affidavit, threatened me, or coerced me. Nobody has promised me anything in exchange for making this affidavit. On August 21st, 2006, I was riding my bike on Crawford Street in Goldsboro, North Carolina, when I heard a series of gunshots near Crawford and Olivia Lane. I rode to the corner of Olivia Lane and Hugh Street in Goldsboro when I saw 2 men in a stopped idling car. As I rode my bike up to the car, I saw 2 young men I knew most of my life. In the front seat, both of them were shot. They were known as Slick and TJ. Rest their souls as well. Mr. Crone was not moving and not conscious and appeared to be dead. TJ was still conscious. Slick had a .45 caliber pistol in his hand, and TJ had a 9mm pistol in his hand. I never saw Roderick Miles Davis at or near the scene on August 21st, 2006. My first act was to take both guns. I noticed they had blood and pieces of flesh on them. Some people started coming near the car, and I called out to others to call for help. After I made sure that the police were coming to help TJ, I rode my bicycle to a park behind the Lincoln Homes apartments and put both pistols inside a barbecue grill to hide them. I know some people saw me take the guns from Slick and TJ. I'm sure nobody saw me hiding them in the grill. The next day I went back to the grill and retrieved both pistols. Later, I gave the guns to a friend to clean them because he knew how to take them apart. My friend gave the guns back to me, and I then gave them to Slick and TJ's friends. The second part of this affidavit reads, I heard that the police were looking to question me for a while before I was actually questioned. I spoke with the police and gave them a statement. The statement was audio recorded with a tape recorder or a digital recorder. I denied ever taking the guns out of the car. I did not tell the police that I had taken guns out of the car and hid them. This was not true. I told this because I was worried about going to jail, and I did not want to admit to taking the guns and facing jail time for that. I already had legal problems going on at the time, and I did not want to add to my troubles. At a later time, I was incarcerated on a robbery charge that originated in Wayne County. On or about March the 10th, 2009, I was at Tabor Correctional Facility when a man named Bob Forsyth came to interview me. Mr. Forsyth identified himself as a private investigator hired by the defense in this case. Mr. Forsyth asked me questions about the case and specifically asked me if I had seen any guns in the car and if I had touched them. I told him no. This was not true also. I told him that because I was worried that I would get myself into further trouble for taking the guns, and I was already serving a sentence that I did not want to extend. I refused to help in any other defense of this case. During the March 2009 trial, I was transported from the state prison to the Wayne County Jail on a writ filed by District Attorney. I was in the county jail for about 72 hours while the trial was proceeding. Nobody came to me during that time period, and I was not called as a witness by either side. To my knowledge, no one from the district attorney's office ever came to visit with me, interview me, or question me about this case. I am making this affidavit now in order to set the record straight about what happened on August 21st, 2006. I am ready, willing, and able to testify to the contents of this affidavit. And this was dated March 27th, 2018, which is about 5 years ago. So because of that statement right there, Mr. Davis is alleging that that is new evidence that should be admitted and should prove that he acted in self-defense. This motion for appropriate relief just goes on to cite case law defining self-defense, and also why Ray's admission of removing a weapon from the scene fulfills the requirement of Mr. Davis being granted new relief, or at least an evidentiary hearing. Now, once again, it goes on to talk about the ineffective counsel. Once again, it talks about Mr. Hoss's time being of Mr. Miles' defense lawyer. Now, at that time, once again, he was actually under investigation or being, at least targeted or questioned about he and his brother situation regarding the death of his brother. So Mr. Davis, Ricky, contends that the trial counsel was conflicted, in which he was. The same people that he was defended his client against were actually, possibly seeking charges for him. Now, also it goes on to talk about the self-defense case, being fired upon 4 times, being having to retreat from your home, and having to defend yourself. That is pretty much due diligence that he was defending himself from people who were regularly firing upon him. Now, his main source, of course, is the jury was never notified of Mr. James Ray's affidavit or his testimony, which they couldn't have been because he did not come out and tell the truth until now. So that would be something critical that the jury may have taken into consideration at the trial. That, hey, this guy says he removed guns from the car, which substantiates Mr. Davis' testimony that those guys were trying to fire upon him, but the guy never testified. But also, once again, the ballistic reports from the police clearly state that there were 3 guns, 3 gun shells in that vehicle. Now, he once again just keeps going on and defending himself. Now, the appeal process kind of denied him on these grounds. They denied him appeal on 10 grounds. Now, one ground is that defendant purchased an assault rifle on the 18th, which preceded the first occasion in which he claimed to be fired upon. And they say claimed to be fired upon, but it's evident, that he had been, because there were several reports of houses being hit in that area during that time. But this first part of grounds, it doesn't matter when that Mr. Miles bought his legally owned firearm. that had nothing to do with that incident and him being self-defense. Also, it says that the defendant did not report the shooting incidents to the law enforcement office or his aunt, which was a police officer. Once again, he was not required to report those things to his aunt, but he stated that once again he didn't want to bring his aunt into the affray. They also denied him, saying that he said that he was at war, which pretty much he was. And then they said the defendant ran from his house and stopped in a location that could be construed as a hiding place and readied his weapon for firing. Once you run, though, you don't have North Carolina is a stand your ground law, so he actually didn't stand your ground say, so he didn't have to run. Now this 5 is very telling. Once again, what I was talking about earlier, defendant fired 15 times, while the available physical evidence only established that the occupants of Mr. Croom's car fired 3 shots. Now, once again, first they're saying that there was no gun in the car, but in this situation right here, they're clearly stating that the defendant fired 15 shots and 3 shots came from the occupants of the car, which would still be self-defense no matter how many times someone fired upon you. You have the right to defend yourself. He said gunshot residue testing failed to establish that Mr. Croom fired a gun at the time of the shooting. However, Croom had gunshot residue on the driver's side door, consistent to with him firing a weapon. And they said that the defendant fled the shooting without checking to see if anyone was hurt. And so in this MAR, Mr. Miles' lawyer goes on to refute each one of those counts that were argued by the judge at the appellate case. And the most clear-cut, unequivocal evidence is the fact of Mr. Ray's testimony, in which was made new at this time. So the conclusion and the relief requested. This is basically, once again, Mr. Davis's request for a new evidentiary hearing. He cites certain cases and substantiates his claim for self-defense. Now, I'm going to read one more affidavit, and this affidavit was written by Mr. Miles, excuse me, I don't know what I'm calling him, Miles, Mr. Davis himself. Now, this one reads, Roderick Miles Davis Jr., being duly sworn, deposes and states the following under penalty of perjury. I make this statement and this affidavit of my own free will. Nobody has forced me to make this affidavit, threatened me, or coerced me. Nobody has promised me anything in exchange for making this affidavit. On August 23rd, 2006, was the day I turned myself in to the local law enforcement officers. After my arrest, I was charged with 2 counts of first-degree murder. Within minutes after my arrest, I was introduced to Attorney Jeff Hoss. On this day, I explained all the shootings that happened at my house. The 4 separate shootings caused by violent gang members, all within 48 hours, which led up to the final fatal gunfight exchange. He says, since day one, I have always claimed my actions were self-defense because the driver, James Croom, pointed a weapon in my direction and fired first. Even counsel Jeff Huss concluded that my case is self-defense and knew the crime scene was tampered with by a black male on a bike who took a gun from the driver immediately after the shooting. In August 2008, I went to court for a hearing. At the hearing, Attorney Huss informed me that in November 2008, I will be entering a plea deal for involuntary manslaughter. Counsel said my sentence will be 26 to 32 months. I agreed to take the plea. The next month, October the 1st, Attorney Jeff Huss was dealing with a lot of stress over the death of his brother. Attorney Huss was out of work for a few months while my case was still pending. Wayne County correctional officers advised me to write the state bar. Although the NC bar never responded to my letter, Attorney Glenn Barfield came to the county jail to question me about the letter to the state bar attorney. Barfield did not mention the involuntary manslaughter plea deal, but did ask me did I want him to represent me. I declined after he told me that he represented Frankie Gervais Holmes on a murder case a few years prior to my case. I thought this would be a conflict of interest because Frankie Gervais Holmes is state victim in my case. On March 12, 2009, after the trial counsel returned back to work, counsel informed me that I will be going to trial on March 16, 2009. When I asked Attorney Hurst about the involuntary manslaughter plea, trial counsel Hurst's words were the DA took the plea deal off the table because of a contradictory statement Correctional Officer Sergeant Will W. Baker is alleging I said, but is now offering me 45 years. Counsel Huss had already turned down the 45-year plea deal. Trial counsel Huss said he would be putting a subpoena out for eyewitnesses William Battle, who gave investigators a statement that specifically mentioned Mr. Battle observing a boy on a bike removing a hand from the driver of the vehicle. And see Exhibit A of William Battle's statement, and I do have that here. But it is a statement saying that I think I left it in the other room. But he goes on to say, when my trial was taking place and while William Battle was testifying, I noticed Mr. Battle did not mention anything about seeing a boy on a bike take a gun from the aggressor. Mr. Battle's testimony only stated that a weapon was removed from the passenger side. I immediately pointed this out to trial counsel Huss, who represented me, and he said, relax, it don't matter what side of the car a weapon was removed from as long as the jury hear that a gun was removed. Now, I agree, but that fact should have been emphasized to the jury. When trial counsel Huss subpoenaed William Battle, he was brought before the court so he, Mr. Battle, could testify to exactly what he told investigators shortly after the fatal gunfire exchange. And that was that he witnessed a handgun being taken from the driver. At no time during my trial did counsel question eyewitnesses Battle about seeing the driver with a gun. Trial attorney Hurst's open closing argument was about the driver pointing and firing a gun at me first. But despite what the evidence showed and what counsel Huss and I talked about right before the trial, counsel Huss still did not show that the driver also had a gun along with the front seat and back seat passengers, meaning 4 convicted felons were riding around in a rental car with at least 3 firearms. My testimony was about the driver who pointed and discharged his pistol at me first, not the front passenger who was too in possession of a weapon, according to Mr. Battle's testimony. I never knew the front passenger had a gun in hand. During my trial, I remember the prosecutor, Matthew Deveridge, was persuading the jury that my case is not self-defense because the driver did not possess a gun nor could not have fired a weapon while driving. Now, this is all throughout the trial transcript pages. At no time in the trial was evidence of my eyewitness testimony ever presented that a gun was removed from the driver's hand after the shooting. Furthermore, trial counsel Huss did not do what he told me he would do at the trial, and that was to have my star witness, Mr. Battle, testify to what he informed investigators shortly after the August 21st, 2006 shooting about seeing a boy on a bike remove a gun from the driver, William Battle. And it goes on to, once again, say that if, William Battle was properly questioned about the statement, he would have been granted the self-defense. Now, this is dated September the 14th, 2023. And so this case, once again, is still being litigated. Now, a lot of the players that I mentioned are Okay, now this is the statement from William Battle as well as seeing a boy take a gun from the car. So all of this is court documents. Once again, this is not something that I am making up. This is something sent to me by Ricky Davis via his mother and father. Now, once again, I was not there. I was not at the scene. Only Ricky and the people who are at the scene know what happened. Only Mr. James Ray knows if there was guns in the car. Only the state's witnesses and the evidence and the ballistic people knows if guns were fired towards Mr. Davis. But I think with the addition of that statement from Mr. James Ray that guns were taken from the car, Mr. Davis's claims of self-defense are warranted or should be at least re-looked at. Now, I know the politics of when something like this happened, when you have a major shooting where two deaths, people lose their lives in broad daylight in the streets. I know the politics of something like this where, the public has to have some type of answer. And, it seems that, Mr. Davis was the answer to this, whether it was self-defense or not. They wanted someone to be held accountable for this act, regardless of if these gentlemen were continuously shooting at him, for days and days on hand. But for all intents and purposes, from the things I've heard, and which can't be substantiated, once again, about this situation, I've heard the same thing that Mr. Miles claims, and also Mr. Ray alleges that there was some tampering with the scene during, the incident. So I'm not here to, pass judgment or say who was right or who's wrong. I'm just here to state the facts that if that is the case, if Mr. Miles was fired upon and he defended himself, then, that should open up the door for him to receive some reprieve, not being sitting in jail for the rest of his life for, clearly or apparently defending himself. So, once again, my name is Richard Taylor. My name is 919-587-7782. I don't have a dog in this fight, but I am for righteousness and for righting wrong. So, if anyone has any information that could substantiate this or, refute this information that I'm reading from this MAR and from these affidavits, please don't hesitate to call me. Or if there's anyone who has any information that will further progress Mr. Miles's cause and seeking reprieve and seeking appropriate relief from this situation, if it was in fact self-defense, please don't hesitate to call me or even call the authorities. Because we have this, once again, culture where we know something is wrong, but because of a certain perceived code or whatever, we withhold information where innocent people are in jail or innocent people die and nobody pays for it. So this may be one of those incidents. Once again, I think he is still slated to appear on an evidentiary hearing, which will bring all of these things into question, especially with the affidavit of the young man saying that he did indeed remove guns from the car, which once again will substantiate consequently Mr. Miles' defense of self-defense. So I'm gonna let you guys go, mull over this, and once again, peace and blessings to everybody. If y'all have any input, once again, don't feel free to reach out to me, 919-587-7782. Peace and blessings. Y'all have a good night.